Carolee Adams, the Eagle Forum of New Jersey. Opposed to the nominee. John Tomicki, League of American Families, several concerns. Nina Arce, opposed to the nominee. Eric Richard, New Jersey AFL-CIO, written testimony, but opposed to the nominee. I think if he's still here, yep, he will be called to testify as well.
I guess I could say good evening to this august body of state senators, and truly I am impressed with the dedication that you've applied to this nomination today. There could be nothing more important that you could address than a nominee to the highest court in our state, a state that has been too often and notoriously known across the nation as, and using the term activist, the most activist in the country. If I may say that I cling to the fact still that a nominee to the highest court in our state should have extraordinary qualifications. Those qualifications are not only experiential, but they're judicial. Judicial meaning that the nominee has been a judge or a law professor, has been a law partner, and our nominee, Mr. Kwon, does not possess that, although he has an incredible resume. And whether or not you approve him or not here today or in the full Senate, I trust full well that Mr. Kwon will have an extraordinary future for himself, and that we need not worry about that. He is a gifted young man. But we still believe, Eagle Forum of New Jersey still believes that there should be some opinions that we could read from a nominee to the highest court in our country. We don't have that advantage in this case. Secondarily, New Jersey is very proud of the Korean population that we have here. My neighbors are Koreans and entrepreneurs, small businessmen. They are extraordinarily dedicated and close families, dedicated to their children's education. And I'm sure that Mr. Kwon's mother and father can still be very proud of him, as they have been probably from the day he was born. Nevertheless, knowing the closeness of Korean families, as I do through my neighbors, through my friends, even though Mr. Kwon has given testimony under oath, I find it difficult to believe that he and his wife, a professional couple, have not discussed the amounts of monies that they have deposited through his parents' business or through his wife's and mother's business, and talking about the restriction of the monies that were deposited in the account. This wasn't just a singular incident. There were 22 incidents amounting to $2 million in less than 10 months. So there is a question about that and why it wasn't pursued. I mean, Mr. Kwon and his wife, Mrs. Kwon, signed joint tax returns, and I'm sure they had accountant advice in a variety of ways. Number three, regarding an accountant, I find it difficult that if I knew that my mother had been duped or my spouse had been duped, either with ill advice by an accountant or attorney, and they were not, for some reason or another, able to pursue the person who gave them that ill advice that could lead them to legal ramifications, I would do everything that I could possibly could to have that accountant's license revoked. I haven't heard anything about this accountant who supposedly gave them the advice to keep the amounts of monies below $10,000. And if he's given the advice, as I read he has, to one business, then he's probably given advice to lots of businesses. And that accountant should be pursued by whomever should pursue in the state of New York to make sure he doesn't continue to advise people as he has been doing right now. I have a daughter. She's a third-year law associate in a New York law firm, so that I do know that giving up a law associate firm in a big city means a substantial reduction in income. People usually do that to enhance their resume if they move over to a law clerkship or they don't have student loans to pay back, and that's their decision. Nevertheless, I do believe sincerely that Mr. Kwon has tried in his best effort to return a certain ethical component to his testimony today. There are certain things that I think lawyers do not want to discuss openly. They don't want to prejudice themselves any more than they have to, and that's understandable. But there are two things that he mentioned that troubled a little bit. One was that when Senator Carolee asked him about foreign law, there have been so much discussion in the United States Supreme Court about the use of foreign law with the United Nations, so that I did not hear specifically, perhaps I would have liked to have heard Mr. Kwon say that his decisions would be based upon the United States Constitution or the Constitution of the State of New Jersey as it was written and originally intended. I didn't hear that, and I don't think he should have equivocated on that in any way, and that leaves me with some question as well, too. I guess, once again, I have been to other other testimonies and nominations of members to lower courts here in New Jersey, and I was always very impressed with some of their credentials.
Ma'am, I'm just going to ask you to try and wrap up. I'll give you a few seconds to wrap up.
I was always impressed, and so that there are very impressive members that are in our lower courts already, and I just wonder if they feel as though there is truly a career path for them if we reach out and grab other people who haven't perhaps followed the more traditional lines of upward mobility in the state of New Jersey and our judicial system, so that by Governor Christie choosing someone like Mr. Kwon, I cannot believe in my heart of hearts that there weren't 50 other nominees that he could have considered who had practical jury trial experience and whose opinions we could read, and I thank you for the time you've allowed me.
Thank you very much. Mr. Richards, just go down the line.
Chairman, members of the committee, thank you very much for the opportunity to speak this evening. We have distributed written testimony. I will be brief. As mentioned, Eric Richards speaking on behalf of the New Jersey State AFL-CIO. And we come before you this evening not to speak to the nominees' legal experience, their background. Obviously, this committee has looked at that thoroughly. We're here just to present one opinion to you, and that is our concern in regard to moving forward with these two nominees as it relates to the independence of the court and the partisan makeup of the court. Very briefly, Senator Weinberg brought up an interesting point and statement when she said the definition of independence is or nonpartisan affiliation is an interesting one. As quoted earlier, we have a situation now where if these two nominees are approved, we will indeed have a court that is made up of 5 Republicans and 2 Democrats. Never in New Jersey's history would there be such a lopsided New Jersey State Supreme Court. Although, as mentioned throughout today's hearings, some have categorized Mr. Kwon as an independent, it has been recognized that he was a registered Republican from 1997 through 2010 until he moved to New Jersey. His recent re-registration as an unaffiliated voter does not alter his long-standing affiliation with the Republican Party. When combined with other sitting justices and nominations, the court, as mentioned, would now only have 2 Democrats. Why is the AFL-CIO and other organizations bringing this to your attention? A letter was sent out that had a list of approximately 30 progressive organizations in the state that were concerned with the same exact issue I bring before you this evening. There's going to be critical issues debated before this court in the future, including issues that are extremely important to our membership, to employees, and to working families throughout the state. Examples include collective bargaining, employment discrimination, project labor agreements, prevailing wage discrimination, arbitration awards, and school funding, among others. For this reason, we respectfully ask that you reject this partisan approach to the nomination process and to encourage the governor, like his Democratic and Republican predecessors, to respect their long-standing partisan balance of the court by replacing at least one of these nominees. Thank you very much.
Thank you, Mr. Chairman. My name is John Tomicki, Executive Director of the League of American Families. We represent about 100,000 households in the state of New Jersey. And I want to note for the record, we did not say we were in support of, nor did we say we were opposed to. We said we had some serious questions and concerns. You senators have the most difficult duty. You have information that we, the public, don't have. I know all of you personally. You all take your job seriously. I think what Mr. Kwon said before goes well, that you may be an adversary, but you don't act adversarially. What the committee has to look at It's his conduct, his character, his legal acumen. That's all there. It's good. The things about his family and his family business, it was sort of hard to hear, but you have a probative job that you had to do. But unless he was involved in their dealings, which apparently is clear he was not, unless he did not act with due diligence, which it appears that he did, and unless he was somehow complicit with something that went wrong, and that I don't think has been shown, there were questions you had to raise, and they should have been raised, and they were raised. But what concerned me the most is this issue that's now been raised relative to balance. And with Senator Cardinelli's questioning about the position that Mr. Kwon would have on certain cases, the biggest case that we deal with in Jersey is Winbury versus Salisbury, where in effect we believe the court took away certain powers from the legislature, took onto itself certain powers. That is what has concerned us when Senator asked about an activist court, and Mr. Kwon got into the issue of looking at foreign jurisdictions. He said he would, but then you went back to stare decisis, trying to stay within the 3-minute rule of the Senate, which I'm trying to respect. Our New Jersey court has a history of reading rights into the Constitution that are not there. It read limits out of the Constitution, which was not right. It has a terrible reputation as an activist court. We opposed one justice at one time, that was Justice Lavecchia, when she said she thought her role as a judge on the court was to fill in the gaps left by the legislature. When you go to law school, you're taught the theory and the concept of stare decisis, but you know there's something, they never tell you the whole phrase. Stare decisis et non quiescit movere, which means stand by the decisions of the court and do not disturb the undisturbed unless there becomes a reason to disturb it. So hopefully when you have an independent judiciary, it doesn't mean a balance of Republicans and Democrats, because you're really going to reflect the state of New Jersey. I think there are a lot more independents in the state of New Jersey than there are Republicans and Democrats combined. So on his answers concerning stare decisis, I wish they had been slightly clearer on what he might or might not do on a case that's going to come before him, and we all know they're coming. So the issue of recusal comes on the table, and some of us believe that the current way that the Chief Justice is interpreting the Constitution, if somebody has to recuse themselves, we believe the reading of the Constitution, we hope the legislature might address this, is that you only allow the substitution if you lack a quorum. That gets to that issue of being a strict constructionist. We would hope that any nominee coming before the Supreme Court would always try to be a strict constructionist. Many times we come here and we also pray for you. This is not an easy decision that many of you are going to have to make. I can only add a cautionary word that what you apply to one standard to Mr. Kwon should also be applied to the next candidate that you'll be interviewing shortly. We are concerned. We hope you could get clearer answers on will he be a strict constructionist, as we know the Abbott versus Burke and progeny are going to be seen by the court. And in the work done by Peter Massey, which has been printed in the Rutgers Law Journal, clearly said that the court should re-examine how they looked at that thorough and efficient system of education. Mr. Chairman, we wish you well. We hope that the decision that this committee and the Senate, if it passes out, we will be communicating our concerns as to the eventual decision. Thank you so much for letting us share, and I apologize for my voice because I've been trying to get rid of this infection for a month.
Thank you, Mr. Tomicki.